Good afternoon, everyone. This is a costs, budgets, legal update and tactics. My name is John Meredith Hardy, and I've got some slides for you to look at. There'll also be a seminar paper which Kelly can email you tomorrow, which she'll also email you together with a recording of this seminar. Now, the matters that we're going to deal with today are a number of key points. So first of all, legal developments. That's the changes from the 1st of October 2020. And then we have a number of other points, references by reference to both the rules and also by reference to various authorities on some of the key points that we all experience and have to deal with in practice. And then we'll finish off with some practical tips and tactics. So just to start with, the changes from the 1st of October 2020. You may already have had an opportunity to see the new practice direction 3E, and also had a chance to have a look at the rules, which were addressed in a statutory instrument, which was first made on the 16th of July of 2020. In large part, the structure essentially is different, but the content is the same. So what we have is essentially a recast practice direction and then a movement of a number of the previous parts of the practice direction into the rules. So what you'll see when you look at the new rules is you'll see new rule 3.12.3, new rule 3.15.5, new rule 3.17.3, new rule 3.15a, and a number of other rules besides. And to, as I say, to all intents and purposes, the content of those is the same as what was previously in the practice direction, although there is in actual fact some material changes and new features which I'll come to in a moment. So that has resulted essentially in a recasting of the practice direction, which now makes a bit more logical sense. In terms of its actual substance, it's now shorter because so many parts of it have now been moved to the rules. But what you do find, though, is the guidance table that previously was a separate document which told you how to address each particular phase and what should go into it in each phase. It now finds itself actually within the practice direction. So what are the new actual features themselves? We have something called relief for oppressive conduct. That is where any party may apply to the court if it considers that another party is behaving oppressively in seeking to cause the applicant to spend money disproportionately on costs, and the court will grant such relief as may be appropriate. So what we have there is essentially is an opportunity for you to be able to go and ask for specific relief. To all intents and purposes, you probably could have done that previously under the old rules. Secondly, we have some new provisions, Rule 3.15a, for revision and variation of approved cost budgets. And there we have reference to a new precedent T, which you will note from precedent T. We have some guidance notes as well. I haven't put up the guidance notes, but you can have a look at precedent T, a copy of which is here. It's the usual type of document, and to all intents and purposes, it follows what you might call a somewhat commonsensical approach to what you would expect with regard to demonstrating what changes there are from the budget as budgeted and the budget moving forwards and is now proposed because there's been a substantial change. As I say, it's commonsensical and it should make variations much easier to be able to understand and present. So just going back to where we were then, to all intents and purposes, as I say, we have the rules are essentially the same. We have a few additional items. It goes forward in a more logical format probably than it had been before, where it had been added to incrementally. But as we look at some of the key issues as they arise, that the that the rates, for example, the range of reasonable proportionate costs, that proposition still remains. You still have to approach matters by reference to cost to be incurred, not costs incurred. So there are no fundamental changes in approach. So now let's looking at a number of issues, if I may. Sanctions for failure to file. As we will all recall, we have Rule 3-14, which of course was the central point that, of course, that Mitchell was dealing with. That remains, no changes with the new adjustments to the CPR, and Rule 3-14 remains as harsh as it ever was. There have been a number of authorities that have dealt with it since Mitchell and in more recent times. First of all, we've got Lakhani, which was a default of only 1 day late. Relief was refused. Seemed somewhat harsh, I think, in the circumstances. The appeal was refused. As we all know, very difficult to appeal case management decisions. Most judges, I don't think, would have taken that approach. Really, the key point, as you'll see from the authorities to which I'm going to refer now, is whether or not the CCMC has to be adjourned. If it does, relief is unlikely. The next case where relief was refused is BMCE Bank against Phoenix Commodities. 2 weeks late. Again, almost the entirety of the CCMC was taken up with relief, and the consideration of the court, primary consideration of the court, was the use of scarce court resources. Relief refused. Between those two authorities was Mott and Long. This was a 10-day late service, so one which was, if you like, more egregious than Lakhani, which was only a day. There had been something of a dispute over expert evidence required, length of trial, and the judge made various decisions following argument. And the view of the judge was that the CCMC never would have been effective, and therefore, once it was determined it was going to happen on another date, in any event, relief was granted, but costs had to be paid by the defaulting party. And then most recently, this year, the defendant's budget was served 13 days late, but relief was granted. Here, interestingly enough, there was something of a satellite argument, I think, which had not been run previously because it was specific to its own facts. The CCMC timetable had been agreed between the parties, and the defendant said they'd essentially been misled by the agreement between the parties, which hadn't included reference to exchange of budgets. It would seem that the defendant wasn't familiar with the rules, which of course overtake any agreement between the parties in those regards. But in any event, the key point was that relief was granted because the CCMC and cost budgeting was still effective. There was no adjournment, so that was a significant factor. So what's the takeout from all of this? Certainly, if you have fallen into error, make certain that CCMC is going to be effective. One way to make certain that CCMC is going to be effective is to agree as much as possible of the budget with your opposite number, and more particularly if the bargaining chip is to agree an unnecessarily high budget on the other side's part in order for them to agree that your budget, notwithstanding, should go in. Hopefully, that might result, therefore, in an agreement between the parties. I mentioned that, however, the Rule 3-14, once it is engaged because you failed to comply with the rules, interesting enough, in Page against RGC Restaurants, now I'll mention that in a moment in a different context, we'll also come back to this point, in actual fact that such an agreement is not binding, but in all likelihood a court is likely to take note of it. Perhaps in Page, for other reasons, they didn't. So what about filing an incomplete budget? That is where specifically the issue was addressed. That issue was addressed specifically in Page. Was this a budget at all? It seemed somewhat unfair to consider that was the outcome. But indeed, it was. It was considered that because certain phases were not included, therefore that it wasn't a budget at all, even though it only had 0,0 for trial, prep, and trial. That was the outcome, both with regard at first instance and at appeal, although the appeal was granted for different reasons. So Master Thornet was considerably unimpressed by that, and determined that there was no budget at all, and therefore the Rule 314 sanction applied. Sounds pretty harsh, and so Walker J so found. So what did Walker J think about this? Well, he did consider it was not a budget, and therefore Rule 314 applied. Still, my own account, I think it seems to me somewhat harsh, and in fact has to be wrong. But nonetheless, that was the outcome, and of course, it's going to present some difficulties for all of us. Certainly in first instance decisions, because it's the High Court judge's decision in what was a long and careful judgment. But nonetheless, with regards to those two phases that hadn't been addressed within the budget, the learned judge nonetheless held that relief should be granted in relation to that, and therefore the Rule 3/14 only applied to trial, prep, and the trial phases, the two phases in actual fact which were incomplete. So what do you do if in actual fact you think that that, for example, there should be a split trial, which of course is where most of these issues had arisen historically, where parties had mistakenly sought to follow their own furrow, if I can put it that way, by seeking to only put in a part budget. Well, you've got two options. You can either put in two budgets, which has to be the advisable proposition, or before the time for exchanging budgets, so you don't, in actual fact, engage relief, you just serve one, but you ask for more time and you ask for limited budgets. My view, and I suspect the most practitioners' views, is that the second route is dangerous. Sensible thing to do is just to do two budgets, as indeed you should with regard to all options. Where you've got significant options, you should put in different budgets to cover those respective different outcomes, so that you're not going to find yourself in some way, shape or form in breach, to be avoided at all costs. So what happens if you are limited to court fees? What about revising budgets? What happens if suddenly various costs are incurred, and then you use your precedent, your nice new precedent T from the 1st of October to identify those increased costs which have been occasioned in consequence of matters which have occurred during the currency of the case? Well, in Ashgar against Barty, it was considered that where there had been a longer trial than had been anticipated, that was a significant development, and therefore you could have revision. And that didn't undermine the original Rule 3/14 order. What about if you're limited to court fees? Is there an escape route? Well, there are two possible escape routes. Some people might be able to think of some others, but I think these are the primary ones. Indemnity costs. And of course, as we know, that's conduct out of the norm. Cost budgeting only applies to costs on the standard basis, doesn't apply to indemnity costs. So look for those opportunities to be able to argue indemnity costs, either with regard to the totality of the claim, if you're limited to court fees, or a part of it. Argue the point, and you might be back in the money. What about Part 36 offers? Well, you've got Rule 36.23, which has these rather complicated and difficult to understand cross-referenced rules, which relate to the recovery of 50% only of the costs assessed, without reference to the limitation. You need to go yourselves if you have this problem, whether claimant or defendant. For defendant, there's a case called Ali, which deals with the point. For claimants offers, the position has not yet been dealt with by reference to any authority, as far as I know, as to the exact meaning of this rule. But in any event, as I say, 50% it seems to be the kick-off and standing point, and practitioners seem to be thinking that that means 50% of costs from the expiry of the 21 days of the offer having been made. In terms of what happens if that offer is beaten at trial. What about hourly rates and budgeting? Well, we've got essentially the same words as we had before, but now in the rules rather than in the PD. Of course, as you'll recall, it's not the role of the court in cost management hearing to fix or approve the hourly rates claimed in the budget. Similarly, when the court is considering these issues, it's thinking about those costs, those budgeted costs, which fall within a range of reasonable and proportionate costs, the touchstone of all budgeting. So whilst we have some different rules, stroke PD, nomenclature, numbering, we have essentially the same terminology. So hourly rates are of no interest, but of course, building blocks they can be useful for. So a few authorities on this as to where hourly rates and budgeting have been addressed, and judicial consideration of the point. Capital Markets against Tava. I rather think that these are a little bit behind the times considering where we are probably in our daily practices, but nonetheless, if you've got some hourly rates which seem to be extremely high and you wish to be able to analyse the issues and how they should be presented before the budgeting costs, then maybe Capital Markets against Tava might be of some interest to you. We also have Arcadia against Telegraph 2019, a little bit more recent. Similarly, you might assist you in your approach to the question of budgeting if you wish to argue some of these points when you've got very high hourly rates. Warbj saying that though budgeting is not the same as detailed assessment, it's almost inescapable for the court to give some thought to the hours and hourly rates that are justified for the work in question. Of course, really he's just stating the obvious by reference to practice direction and rules. Which is that whilst the court can't set them, they're going to look at the building blocks to decide whether or not the time spent is to all intents and purposes falls within a range of reasonable proportionate time, essentially applying that test to the timings as well against a reasonable proportionate hourly rate to arrive at something which one might think was a reasonable proportionate outcome, but of course always within a range. So whilst the court's not going to be working out hours times hourly rates, it's got to have something to take them from A to Z. So in a sense, to say, just pointing out the obvious. What about the practice of some courts simply to have said, either in a recital or otherwise, which is often the practice of some judges, such as Master Davison, or in actual fact was the position taken by certain practitioners, which was to have a recital in the draft order saying any budgeted costs were still subject to challenge on the hourly rates at DA. No, can't do it. Master Davison, I'm afraid, was slapped down, and it's wrong to leave the hourly rates to detailed assessment. So you've got to deal with it. You can't have any caveats. That's it. So, well, what about unrealistically low precedent H&R? What do the judges make of that? Sometimes a bit of a tactic we see, both more normally on the defendant side. Is a defendant likely to get any traction through being able to say you should look at our low precedent H and the low suggested precedent R? Well, you do stand the risk, of course, of the rather trenchant outcome, as was the case in the Fine Charm against Churchill, who considered it to be so unrealistically low, both in terms of H and R, that took absolutely no notice. In actual fact, Coulson J, as he then was, simply approved the claimant's budget in full. So not a very helpful outcome. And of course, as we know, and as we'll come to at the very end, one of the considerations for a defendant is always to have enough money within the budget so that Part 36s have some value associated with them. So unrealistically low budgets aren't necessarily helpful for that reason too. What about the status of a precedent R offer? Is it something below which the court cannot go? Well, you may well be that you have had the fortune or misfortune to have appeared either in front of Her Honour Judge Boucher or alternatively have one of your cases determined by her. My own experience is do not go before her with a budget which has anything like what one would think, whether for a defendant or a claimant, reasonable and proportionate costs on it, because she will unquestionably think they are too high. So if you're going to appear, or your case is going to appear in front of Her Honour Judge Boucher, my general view and opinion is you should agree costs between you, because it is not unlikely that Her Honour Judge Boucher will take a very significant red line to whatever is being proposed by either party. In this particular instance, in Gray, the outcome was that she went even below the precedent R figure. Was that a basis for appeal? No. What about drafting the precedent R? Just a few points. Don't include costs incurred unless you agree them. You can agree them, but sometimes one sees them being included by mistake. So if you include them, only include them because you want to agree them and want to, if you like, oust the opportunity for having those costs incurred assessed in due course. Don't use the other party's hourly rates with some kind of caveat, as you see sometimes in precedent Rs, because if it's accepted, you can't challenge the hourly rate later on. I'll come on to that in a moment. If errors are made, so double check it, have a jolly good look at it. If you then subsequently identify that some errors have been made, withdraw it, correct it, reserve it. Just remember that if the precedent R is accepted, it's an enforceable offer. It's an offer and acceptance. It's enforceable as an acceptance then as a binding contract. So to be careful. What about agreement of cost budgets? Of course, no doubt many courts will be absolutely delighted that the parties agree the budgets. I don't believe, I've certainly not seen one, it may be that I'm wrong on this, but I've not seen a case yet where a court has refused to approve an agreed budget. There was a Coulson J, I think there was, a decision in the TCC pilot where he got a bit uppity about that, and I think he wasn't very keen, but the wording of the pilot was different from the rules as they are currently. Although, of course, you can see any agreement somewhat being unravelled by the court making directions which are so inconsistent with the budget assumptions that, to all intents and purposes, the agreement of the parties is out the window. So, notwithstanding agreement, you can see how things can be unravelled. Of course, and as I mentioned earlier on, what about the rule 314 and agreement? Look at Page against RGC Restaurants at paragraph 128. According to the learned judge in that case, the answer was no. Once rule 314 is engaged, that's it. Okay, what about the status of the budget detailed assessment? Now, it's always important to bear in mind what the status of the budget is at detailed assessment, because it just emphasises to everyone just how important the budget is. Because to all intents and purposes, you are stuck with those budgeted costs. So let's have a look at Harrison, which deals with these points. So costs incurred obviously are subject to detailed assessment unless, of course, they've been agreed. As I mentioned earlier, you could have agreed them in the precedent R, agreed them at the budgeting, at budgeting. Unlikely for most parties. Most parties will want to leave costs incurred to be subject to detailed assessment and negotiation. So costs to be incurred will be determined by reference to each phase according to the budget, unless there is good reason. So what is good reason? And it's important to know what these good reasons are, because if you don't know what these good reasons are, you don't necessarily know how important the budget is when you're dealing with the process at the CCMC. So first of all, just to look at what Harrison said about it. They said it will be difficult to establish, and cost judges should therefore be expected not to adopt a lax or overindulgent approach for the need to find good reason, if only because to do so would tend to subvert one of the principal purposes of cost budgeting, and thence the overriding objective. So the theory should be that once you've got the budget, you're stuck with it. And so subject to the indemnity principle, the paying party has to pay the costs in the budget, subject to those costs within that particular phase having been incurred. So what about the incomplete phase? Well, there have been a number of recent cases. First of all, Bart's Health NHS Trust against Salmon from 2019. HH died, in actual fact, sitting with Master Brown, who somewhat changed his tune in Utting, as you'll see if you read the judgment. Anyway, so incomplete phases was considered by His Honour Judge Dyke as a good reason to depart and get stuck into a nice line-by-line detailed assessment. District Judge Lum in Birmingham thought utter nonsense. Very clear evidence of obvious overspending in a particular phase would be required before the court could even begin to entertain arguments that there was a good reason to depart from the budgeted phase figure if the amount spent comes within the budget. And Master Brown had a bit of a rethink then, considering he was wingman in Barts, and then agreed with District Judge Lum, although with a little bit more nuance perhaps, because he'd somewhat compromised his position because of what had happened previously. So just going back to where we were before and going back to Harrison, it's the adopt a lax or an overindulgent approach. So where does that take us then? Part complete phases subject to the indemnity principle. That's money for the party, for the party to be paid to essentially spend up to that, unless you see very obvious overspending. So get that budget right, because you're not going to be able to get good reason simply because they haven't got the whole way through that particular phase when the case settles, which so often, of course, does happen. And then you have to ex post facto address the question of costs and certain phases. So keeping each phase down is very important, because you're not going to get an out for good reason because of good reason because of a part complete phase. What about hourly rates? We had three cases. First of all, Deputy Master Campbell's, apparently hourly rates were considered a good reason, has to be wrong. Followed by Nash, Master Nangalian, considered no hourly rates, no special status. We're talking about reasonable and proportionate costs for the totality of the phase within a range of reasonable and proportionate costs. So the answer is hourly rates not relevant. Followed in Jallow against the MOD. No subsequent cases as far as I'm aware. I think that point has been put to bed. So difficult to find good reason then. What about range of reasonable proportionate costs and the question of overarching proportionality? It looks like there is something of a look-see coming in consequence of West versus Stockport NHS Foundation Trust. This seems to run somewhat counter to the approach in Harrison, which was hoping that there would, on all intents and purposes, be a significant degree of finality with regard to budgeted costs. West against Stockport NHS Foundation Trust is providing something of a review on global proportionality. Look at the three stages I've got up on the slide. It's not that easy to follow might be something of a way out for a paying party and worth considering. So, tactical approaches of cost budgeting. First of all, one of the points obviously for a claimant, and it's relevant to the question of proportionality. Has the claimant, this is what the claimant should be saying to itself, have they properly pleaded their case? Because of course, if they got TBA in their schedule of loss, and the total only comes to twopenny halfpenny, but nonetheless it is thought in due course the case might be worth something or something significant, then a claimant might find themselves at risk on proportionality. So if you're for a claimant, you'll probably want to file and serve a schedule of loss that properly pleads the claim ASAP and well before precedent H's are exchanged. So well in advance of 21 days. And for a defendant, sit on your hands, watch the claimant fall into the man trap of not being able to support proportionality because they've got a rubbish schedule. So keeping your head down on that particular issue is always a good idea. Be reasonable and realistic on both parts, because otherwise you might end up with the Coulson J approach, which is I'm not going to take any notice of anything which is said by the other party because they've been neither really reasonable nor realistic in their precedent H or precedent R. Also bear in mind the point about Part 36s. What about Part 36s? Are they going to have any traction? They might have little or no traction if in actual fact your budgeted sums are so low as to be insignificant, and for example, a claimant might not care less whether it's beaten or not because they know the cost set off is not a significant figure. Be careful not to include incurred costs in offered figures in precedent R. In your H, make use of contingencies. So if you believe there are things that which are likely to happen and they've been canvassed in correspondence possibly, or just because there's a difference in view taken by the parties, then make use of the contingencies and put them in there. They're often overlooked, particularly, for example, with different areas of expertise, where there might be something of an argument about which experts are to be used or not. Of course, you could use the experts phase, or you could use the contingencies phase. For example, if you don't agree that certain experts should be called, then don't put it in the experts phase, but put it in the contingencies, and then make it clear in the assumptions that it's only there because the other party is saying that expert is required. So make certain that you've covered all the bases, if you like, dealt and addressed with the counterpart costs that the other side are addressing. Even if you don't agree it, then use your contingencies to draw out what those costs might be, so that you in actual fact end up at the CCMC, if a court makes an order that expert, for example, is to be granted permission to put in a written report. In those circumstances, the costs can then be addressed. What about split trials? We mentioned that. Make sure there are two budgets or maybe multiple budgets on a number of different scenarios. Check the accuracy and each phase is complete. Don't put in an incomplete budget and think that you'll be able to get away with those parts being approved and without those parts being approved. After all, you might, for whatever reason, find that the totality of your budget is out, or alternatively, you being limited only to those parts that you have put in your budget. Make sure it's legible and printed clearly, as often seems to be a problem, a practical problem. District judges and masters have a habit of getting very hot under the collar. I've even seen circumstances where a district judge has adjourned the CCMC because of illegible budgets and awarded costs against the party who provided the document which couldn't be read properly. Please follow the guidance notes. They're now in the practice direction from the 1st of October, although it's it is essentially the same guidance notes as were enforced from the year previous, and include specifically the reference to the fact that the CCMC costs are costs incurred, not costs to be incurred, so make sure they're in the right part of the budget. And similarly, the brief fee is in trial preparation phase and not in the trial phase. So follow the guidance. And the guidance is also helpful just generally in how you should be approaching all of the assumptions. So always go back to the guidance and make sure it is followed. What about negotiating and budgeting? So if you're negotiating, always do it based on certain directions. So be careful, as it seems to me, to predicate the discussions on certain directions, outcomes. Obviously, in more straightforward cases, it may well be that the parties there's no disagreement between the parties with regard to what directions there might be. But in more complex cases, where there are arguments about for example, where there are arguments about expert evidence, and this is the key area that we see problems, very significant costs associated with experts, both in terms of solicitor time and the experts' fees, possibly counsel input as well. Make sure that the discussions and any subsequent agreements are predicated on certain outcomes. Similarly, the precedent R should be so predicated so that it is clear that you then don't get stuck with an agreement to a certain budget sum, which is inconsistent with the actual directions which are then made. Know your court. If it's unlikely to be sympathetic, get an agreement going between you. Have a think about the prospects on budgeting where proportionality is likely to be an issue. Again, this might be circumstances where you might want to agree for a certainty. And what about the conduct of the CCMC? Well, I think that the one point that comes out of the totality of this talk is just how important it is to get budgets right, because once you've got your budget in place, you are, as to all intents and purposes, stuck with it. So make certain that it is conducted carefully and by competent counsel or solicitor. With regards to that to that CCMC, the final outcome needs to be clear. What matters are being dealt with, what matters have not been dealt with. Obviously, if you're not present when the budgeting is dealt with, you'll want a very thorough note and some detailed feedback of what parts of the budget were not addressed. And more particularly, it is helpful for there to be recitals. I mean, for example, a common point which is raised on budgeting is that the cost of experts giving oral evidence at trial is left over to the pre-trial checklist or the PTR. That affects both conference between counsel and solicitor pre-trial, also covers that is the trial preparation phase, and also the trial phase itself, which is the expert attendance. Very rarely is it the case, of course, that all experts have to attend. One expert might attend, but the others be read. And obviously, if all the experts are included in the trial phase, there might be very significant costs associated with that phase, which in actual fact are never going to be reached, and which will muddy the potential waters in terms of outcomes for the paying party when it comes to the question of detailed assessment. And just remember the points that I've made previously with regard to whether or not you have a problem, whether or not you are able to show good reason, rather, when it comes down to part completed phases. So it's important to keep certain costs, if at all possible, out of the budget in their entirety and for them to be dealt with later. And a recital can address that particular point specifically. And of course, only budget what is more likely than not. So part 35 questions, which everyone always says they're going to ask but don't, particularly where there are counterpart experts. So how often do people in actual fact ask part 35 questions when there are counterpart experts? Sometimes, but not more likely than not, but frequently included in budgets. Knock them out if that's to your advantage. Again, similarly, people often include in their budgets Part 18 requests. Are they more likely than not? Probably not. Knock them out. and they can be dealt with subsequently if indeed either Part 35 questions or Part 18s are asked. So all of those points, I think, just emphasise the importance, I would suggest, with getting budgeting right, spending some time and effort addressing it, because as we all know, not infrequently, the costs involved in a case can be equal to or exceed the damages in a claim, or be a significant proportion of the value of the claim. So investing in careful pre-CCMC time and effort in budgeting both precedent H, precedent R is absolutely worthwhile in my view, and I hope that all of these points have been of some use. And that is, I think, is the last point I wish to make. Now, Kelly will email you a copy if you want it of the recording and the seminar paper. In fact, not whether you want it or not, I think she's going to do it anyway. So she'll send that through. There is a Q&A feature. So if you look at the top of your Zoom, you can see there is a question and answer. If anyone's got any questions and answers, I can address them now. So would you like to ask any questions? I don't see any questions being asked. Well, thank you very much this afternoon for listening to this seminar. I hope it's been of some help in bringing you up to date with the changes from the 1st of October. I would suggest that it would be helpful for you to look at the revised practice direction and the revised rules themselves and absorb their content. I can see there is an answer. Do any judges understand economics? Well, probably the answer to that is no, and they certainly don't have much sympathy for the economics of running a solicitor's practice. I think that has to be right. Or business for that matter, quite right. Yes, no, it's a question of whether it falls within a range of reasonable or proportionate costs. And as we know, one of the issues sometimes with dealing with those judges who have been out of practice for some time in the district judge, in the circuit, in the county court, is of course they're somewhat out of touch with what real costs are. And of course, if you're dealing with masters who might have been barristers, and of course they, apart from when they dealt with cost budgeting on their own account, which is a bit of a query as to whether or not they're a recent master or not, the answer is they probably never dealt with it in practice at all. Although one has to say that generally speaking, yes, I have to say that generally speaking, one does tend to find that the QB masters are pretty generous on costs. So it's a good place to be if you're a claimant, not such a good place if you're a defendant. And of course, yes, Her Honour Judge Boucher. Yes, I don't think we need to say any more about her. Good. Well, thank you very much. I think that's the totality of questions and answers. I hope that all of those points have been helpful. And as I say, Kelly will email you the recording and the seminar paper which accompanies this talk, which I hope will be helpful to you and something of an aid memoir of some of these points which I've raised. Of course, these are my opinions. It may well be that in actual fact, it is the case. You'll have to form your own view as to the accuracy or otherwise. Just something of a plug for the next seminar. So Nigel Spencer-Lee on the 13th of October is doing a seminar on fatal accidents. So if you wish to have an opportunity to see that seminar, then you'll need to be in touch with Kelly in due course when she sends the invite. So thank you very much and good afternoon.